Gary, good morning to you.
Good morning, Michael. I don't want to talk about any of the recent things that you've been mentioning, but I want to go back to what you were talking about before the Stephen Hoadley interview, which was the treaty. And the reason why I'm ringing, and I might say that I'm a King's Counsel, and so I approach issues in relation to the treaty from a legal perspective. And one of the things I find frustrating, and I might say quite distressing, is the inability of many people to actually focus on the facts. And the first thing I want to mention in that regard is this two treaties, or two texts of the treaty nonsense, as I would call it, because the facts actually do not support that view. What actually happened, as indicated by contemporary evidence, and in particular by the notes that William Colenso took at the time on the events of the 4th and the 5th and the 6th of February 1840, is that on the 4th, Hobson gave Henry Williams, the missionary, some documents, and we don't know precisely what they were. One can only draw inferences about that. And he asked Williams to translate or to produce a treaty in the Maori language. Overnight, between the 4th and the 5th of February, Williams produced a document in Maori language. The next morning, the 5th, that was discussed between Hobson and Busby. Williams discussed it with Hobson and Busby. Busby, who also spoke the Maori language, made some suggestions for changes, and they were made. And then the document so produced was read out to the assembly that had been, which was on the at Waitangi, having been summoned by Hobson after he arrived in New Zealand by proclamations of the 30th of January. Prior to Williams reading out what had been written in Maori, Hobson read out something in English, but we don't know what it was because whatever he read out has been lost. And then there was great debate, and all of this has been faithfully recorded in notes that he made at the time by William Colenso, who was the printer for the Church Mission. And he reported what was said by the chiefs who spoke on the treaty grounds at that time. And then at the end of that dialogue, the parties adjourned, and then they came back the next day, the 6th of February, and overnight, obviously, there had been dialogue between the chiefs as to whether or not they would sign. Some did, many did, and a few didn't. And so the treaty in Maori, or Waitariti, I think is the best way of identifying it, or to distinguish it from whatever was in English that Hobson read out to the Assembly, was signed. And then thereafter, in the ensuing days, in the north in particular, and a bit later on around the rest of the country, Waitariti was signed by Maori. Now, if you approach the matter from a legal perspective, there is only one treaty because whatever there was in English was not signed, apart from an isolated case down in Port Waikato, and where some of the chiefs there and Hobson signed a version in English. This was in April, and also some chiefs from the Manukau Heads. So in total, there were 39 people who signed that English document. But clearly, the important one is what was signed at Waitangi, and it was in Maori. Now, the idea that there are two treaties is a creation of Parliament, which really, quite frankly, has mucked things up dreadfully. Because in 1975, well, in fact, go back to in 1972, in its manifesto for the 1972 election, the Labour Party said that they were going to create a new holiday, New Zealand Day, for the 6th of February. And they would also investigate ways of giving some sort of practical effect to the principles of the treaty. Now, the person who was in charge of that was Matthew Arthur, but unfortunately Matt had a heart attack during the term of that government, and I think it's a bit unsure as to actually who sort of drove the thing forward within the Parliamentary Labour Party. But whatever it was, eventually in 1975, the Treaty of Waitangi Act was enacted, and it did two important things. First of all, it said that there were two treaties, and two texts of the treaty, and it put them in a schedule to the Act. The second thing it did was to say that there were principles of the treaty. And that is what has given rise to all the problems that we.
Can I take you back on that? Did the Treaty of Waitangi Act of 1975 actually mention principles, or was that rather an invention later on of Geoffrey Palmer when he put them into various pieces of legislation in the late 80s, like for example the State-Owned Enterprises Act?
No. The 1975 Act was the origin of principles. In the preamble to the Act, the preamble actually states that there are two texts of the treaty and that there were...
Oh, yes, you're absolutely right. Here it is. I've got it here. Where it is, this is when it establishes the treaty, and whereas the text of the treaty in the English language differs from the text of the treaty in the Maori language, and whereas... So they recognise that difference. And whereas it is desirable that a tribunal be established to make recommendations on claims relating to the practical application of the principles of the treaty. You're absolutely right. Okay. And for that person...
So that's the origin.
And,
and later on in the Act, in Section 6, I think it is, where the jurisdiction of the tribunal is stated, it actually specifically says that the tribunal is to receive claims from Maori and to ascertain whether there have been actions which were inconsistent with the principles of the treaty, and they might make recommendations accordingly. So that's where it all started, and then subsequently Parliament started including these so-called treaty clauses into legislation, including most importantly into the State-Owned Enterprises Act 1986, the meaning of which had to be interpreted by the Court of Appeal in the 1987 Lands case. But before we talk about that, if you want to, I just want to go back to 1840.
Yeah, just before we start, just before you go back there, Gary, in some ways, though, isn't it almost irrelevant what happened in 1840 or what the intentions were, because that treaty had no legal status in New Zealand, presumably, until it got its own Act of Parliament in 1975, yeah?
That is absolutely correct. And it was affirmed over the years from time to time that domestically, whatever its effect might have been in international law, that's to say, in an agreement between states, which doesn't really make sense because New Zealand, it wasn't a state, it was a collection of tribes up and down the country who exercised quite jurisdiction within their own areas.